Hi everyone, you are most welcome to yet another session of our class. I welcome you and I hope you can enjoy this class as well. God, thank you for bringing us here and teach us your ways of life, but also grant us the spirit to learn what we are going to be going through here. Amen. Today, I will be talking about court and court system in Uganda. As a lawyer, it is very difficult to talk about lawyering and court. In fact, the law and the lawyering and court, they are one and the same thing. So it is very important that you know what court is and how court functions. I will try as much as possible to make you appreciate the profession you have taken, especially in regards to court. Um, First of all, I want to draw your attention that the content of this presentation is largely these laws: the Constitution, the Judicature Act, the Magistrate Court Act, the Local Council Courts, I'm sure, and other enabling laws. There are some other laws that I may not include them here, but these laws I have listed, I sent you a copy as well. So please, as you read the content of this work, make sure you read the content of these laws as well, because it will help you to understand much better than what I'm going to talk. So, when we talk about the courts, what are we talking about? This whole aspect of court has an association with the judiciary. In fact, the judiciary itself is the court, is the interconnection of different courts and court system. But in our legal profession, we are always asking the question of establishment. What is the authority establishing an authority? How does this one come into existence? So the judiciary, the entire judiciary, I would refer you to chapter 8 of our constitution. It has a lot of things talking about the judiciary. And I managed to figure out some few portion of the law to enable you appreciate the establishment. So our court in Uganda are entrenched and established under the law, to be precise, the Constitution, which is the grand norm. Under Article 126 of our Constitution, its provision is to the effect that judicial power is derived from the people and shall be exercised by the courts established. So the court established, we will see them today. These are the courts established under the law. One, the Constitution, and some other courts have been established under the Acts of Parliament, which I have previously explained that there are certain authority that gets their power from Acts of Parliament. But some of our courts get their power from the Constitution. Though all of them get their power from the Constitution, some are more direct than others. Article 128 is to the effect that the exercise of judicial power, the courts, shall be independent. Article 126 actually says that the power that the courts get, they come from the population. The population entrusts the courts with the power to preside over cases. But also, the Constitution now says that when the courts are exercising the power given to them by the people, they must exercise it according to the law that also the people have put in place. So you can clearly see that under this article, the power belongs to the people. And secondly, Article 129(8) In the exercise of judicial power, the courts shall be independent. Now, this means that inferences, confusion, or any disturbance from the other arms of the government, whether it be an authority or an independent person, you should not confuse, you should not get mingled up. You should not persuade the courts when they are doing their work. They should do their work independently. And Article 129 stipulates that judicial power of Uganda shall be exercised by the courts of judicature. And these are the courts we are talking about. There is no any other authority that is mandated to exercise judicial power except the courts. And if it is not the court, it must be an institution that derives its power from the law. But in this context, I'm only talking about the courts. So, the courts of judicature in Uganda, they are the Supreme Court, the Court of Appeal, and the High Court of Uganda. But also we have other subordinate courts. These subordinate courts includes the Magistrates Court, the Local Council Court, and all other courts as Parliament may by law establish. So even there are many other courts apart from the ones I have talked about just now. The law gives Parliament the mandate and the authority to establish other courts by an act of Parliament. However, this session about the courts, it is precisely designed to enable you to be in position to know the meaning, what court means, but also how court functions and the other different roles that courts play in the community. As a way of introduction, it is very important that all of you, as the students pursuing law and the legal profession, you should ask yourself the following questions. These questions are put down here. Because if you ask yourself this question, please look for their answers as well. When you get the correct answers, you must be able to understand each and everything about the court, how they function, and so on. The first question you need to ask yourself is, what is a court? Honestly speaking, we talk about courts. What is a court? Please do your research and find out what court is, especially the legal meaning. Secondly, why do people go to court? Because not everyone goes to court there. There are reasons why people go to court. Some of you, perhaps, you might have been in court already for reasons best known to yourselves. Whatever the reason is, please do more research and know why people go to court. And thirdly, how does court functions? Ask yourself this question and look for the answer. Number 4, who creates court? This is the question of establishment. It is you and me that gives power to the Constitution, which is a law, and therefore it is the law or the Constitution that establishes or which creates the court. You should also ask yourself the question, where does court power comes from? Who creates it, and where does court's power comes from? And you should also ask yourself, what is the role of court in our society? Because these institutions are not just put for nothing. They are put for a reason. So what is their role in the society? And finally, ask yourself, to whom is court accountable to? Ask yourself these questions. I really implore you that you need to ask yourself these 7 questions. If you can get the answer to this question, then ultimately you are one of the best law school at UCU, but also in the country. So let us start from the lowest level of court we have. We are talking about the courts and the court system. The court system is that we have a, a system which encompasses many courts, and these courts are arranged in hierarchies. So that is the system we have. We have the lowest court, we have the highest court. That is the system of courts that we have in Uganda. And it encompasses so many interconnected systems. However, I am going to talk about the different type of courts and how they function in relation to other courts. So, in our hierarchy, we have the local council courts, commonly referred to as the LC courts. So, some of you who have lived or know about village matters, this is where the court presides. So, there is established a local council court at every village, every parish, or town, or division, and sub-county level. This is found under Section 3 of the Local Council Court Act, which I've sent you a copy. Now, also, I want to take cognizance that some of you do not know what a village is. You don't know what a parish, a town, division, or sub-county is. Please, try your best, ask, inquire from your parents, from your friends, from your mates what these things mean and where they are found. So under this level, this is where the courts are located. A local council court may be held at a designated place within the limits of its jurisdiction for the discharge of its business. These local council courts, they do not have a specific place where you go. However, each time there are matters for determination, it is constituted and designated at any place of convenience where it can carry its function without interruption. The jurisdiction of the local council court extends only to matters arising within the geographical area of its establishment. When we talk about jurisdiction, we are talking about the power that the court has to preside over a matter. And we are saying that for the local council courts, it depends on its geographical delineation, the geographical boundary, the geographical area where it is situated. That is where the jurisdiction stops. So an LC1 of Mukono an LC1 court of Mukono cannot preside over matters of LC1 in the neighborhood. Maybe within Mukono municipality, the other one in Seta. Or just know the geographical boundary. That is where the power of the LC court stops. If it is LC2, it also has a geographical boundary. LC3 has geographical boundary. To be more precise, LC1 jurisdiction stops at a village level. LC2 stops at the parish level. And LC3 stops at the sub-county level. And so, some of this division and town, their jurisdiction is ascribed to the sub-county or the parish, depending on the location, but also the matter they are dealing with. Legal jurisdiction in civil matters. When it comes to civil matters, the local council courts only deals with issues to do with debts, assault, damage to property. Issues of property could be if somebody's animal destroys crops in another person's garden, destruction of property, trespass, dispute on customary land, issues of marriages, divorce, especially customary marriage, divorce, identity of customary heir. Now you see some of these things we are talking about, they are practical at the village level for parish or sub-county level. People fight for this position. So these local council court people, either at the village level or parish or town or division or sub-county, if there are matters to do with identity of customary hair, then they are consulted. They have the power to handle such matters. So I want to implore you and encourage you, please read the Local Council Courts Act as I've sent it to you. The local council court may make an order, you see, after presiding over the case. These cases are listed here. They have the power to make orders. They can ask for reconciliation. They can make a declaration or ask aggrieved parties to be compensated. Can also ask for costs. Can also ask you to apologize. They can attach your property, or they can attach and sell. If you've collected a debt and you fail to repay, the local council courts, they have the power to order your land or your cows or your cars or any property you have to be attached and given back to the person you are owing the debt, or can sell it and give the money. So please go to the Local Council Courts Act and read. You'll find so many other details about it. From the magistrate's court, if your matter is if your matter issues to do these issues here, if it is handled by the local council courts and you are not contented, you can appeal to the magistrate's court for consideration. And I have sent you the Magistrates Court Act. All these details are there. But I just want to demonstrate in hierarchy from the local council courts, we have the Magistrates Court. And we used to have Magistrates Court, grade 3, but it has been repealed. Now we do not have Magistrates grade 3. We have Magistrates Court starting at grade 2. And usually they are referred to as G2. That is Magistrates grade 2. This court, Magistrate grade 2, is presided over by a magistrate who must hold at least a diploma in law. So this means that after you finish your law degree, you will be overqualified to be Magistrate grade 2. And if it comes to dealing with criminal matters, their power to handle criminal matters is limited to offenses that are specified in the first schedule. So sometimes this one is read as schedule or schedule or schedule. Depends on how you read it. So the first schedule of the Magistrate Court Act, which I have sent you, please go and open and read it. Those are the limitation. Anything beyond what is specified under this schedule, the magistrate grade 2 has no power to deal with it. If the magistrate attempts to deal with such matters, it will be a case of illegality. You can appeal to the higher authority, which is magistrate grade 1. However, when it comes to dealing with civil matter, the power, which is the jurisdiction of magistrate grade 2, is limited to cases whose sub-values does not exceed 500,000 shillings. So magistrate grade 2, if you have a property whose value exceeds 500,000 Ugandan shillings, then the magistrate has no power or authority to entertain or to deal with that case. So the reason why I am telling you this, that as a lawyer, you should know that if your client has a case whose value exceeds 500,000, automatically you don't need to go to magistrate grade 2. The same applies to this criminal jurisdiction. If the issues of your client is outside what is specified in this schedule, then it's not the right court you should go to. The territorial jurisdiction, this is geographical. The geographical area or jurisdiction is limited to their counties where they are normally situated. So, politically, we have counties. Magistrates grade 2, they stop within a county jurisdiction. From magistrate grade 2, if your subject matter was not dealt with appropriately or you are not contented, you can appeal to magistrate grade 1. So, magistrate grade 1 and the chief magistrates, they play much similar role. But I want to encourage you still, please read the Magistrates Court Act. It has more details than what I'm presenting here. The Chief Magistrates Court is presided over by the Chief Magistrate. Now, this Chief Magistrate is somebody who has a law degree. So when you finish your law degree, you will be qualified as Magistrate Grade 1. Usually, to become a Chief Magistrate is a matter of promotion. You have to perform extremely very well in your exercise of duty. That's when you can be promoted to the Chief Magistrate position. But ideally, when you finish your law degree, you would have qualified to be Magistrate Grade 1. But of course, after you have finished LDC, this court tries all cases except criminal cases whose maximum penalty is death. So, Magistrate Grade 1 and Chief Magistrate specifically, they have the power to try all cases except if it is a criminal case which is so heavy that it attracts a death penalty. There, the magistrate cannot preside over it. The Chief Magistrate may also pass any sentence authorized by law except death sentence. So the Chief Magistrate can pass any sentence except death. The Chief Magistrate have jurisdiction. So when it comes to handling civil matter, if the value of the things does not exceed 50 million, then the Chief Magistrate and Magistrate Grade 1 can handle such matters. So if you have a property, you have debt, you have anything which is civil in nature, but the value of the subject matter in contention does not exceed 50 million, then the Magistrate Grade 1 and the Chief Magistrate can handle it expeditiously. The Chief Magistrate exercises generous, apart from the work they do, they also supervise. The Chief Magistrate Court, they supervise the Magistrate Grade 1 and Grade 2. But I want to encourage you, if you want to learn more about Magistrate Grade 1 and Chief Magistrates, please make use of the Magistrates Court Act that I sent to you. The Chief Magistrates Court is presided over by the Chief Magistrate. This court tries all cases except criminal cases whose maximum penalty is death. The Chief Magistrate may also pass any sentence authorized by law except the death, and so on and so on. However, we also have something known as the Industrial Court. This court was established under the Labor Dispute Arbitration Settlement Act. This court only, the Industrial Court, it only entertain matters either referred to it by other courts, or if a person in dispute goes directly to it. They only deal with matters concerning the industry, dispute within the labor department. This is work related. This court was established to arbitrate labor disputes. Refer to it under the Act. So, matters of employment, matters of issues arising at workplaces, you can go straight to the industrial court, issues of payment, work environment, and many others. You can go to this court. And I want to add that the Labor Arbitration and Settlement Act is one of the laws that you need to read. Somehow I forgot to send you, but you can search for it and read the content. Now, from the magistrate's court in hierarchy, we go to the High Court. So the High Court and any other court after here that I'll be talking about, they are called courts of records. They are superior courts of record. The High Court, now these courts are established under the Constitution. The Local Council Courts is established under the Local Council Courts Act. The Magistrates Courts are established under the Magistrates Court Act. However, the High Court, the Court of Appeal, and the Supreme Court, they are established under the Constitution. So if you go to Article 138, you will find the establishment of the High Court. Generally, it provides that the High Court is headed by the principal judge. So the Magistrates Court is headed by the Chief Magistrate, but the High Court is headed by the principal judge, and also it is constituted by many other judges. It's not only the principal judge who sits in the High Court, but there are other judges as well. There are very many of them. The High Court shall have unlimited original jurisdiction in all matters. So what happens here is that any case, there's no case which is big for the High Court to deal with. All cases. That is why we say the High Court has original jurisdiction. It has unlimited original jurisdiction. You saw in the Magistrates Court and the Local Council Court, others were limited, especially for civil matters, by monetary terms. Others were 50, others are 20, and so on and so on. However, for High Court, there is no limit. They handle any amount of money. The subject matter might be valued. And when it comes to criminal matter, they do the same. So the decision of any court lower than the High Court shall be appealed to the High Court. Decision from the Magistrates Court come to the High Court. The High Court has the jurisdiction to determine validity in election of members of parliament or even the Speaker of Parliament. They can entertain such cases. So the High Court has so many divisions. We have the anti-corruption division, we have the civil division, we have the commercial division, we have the criminal division. So each of these divisions handles matters specifically ascribed to their description. For example, in the High Court, we have a section of a division that deals with corruption matters. Others are civil, like that. So we have also a division that deals with execution and bailiffs. There's a division that deals with only family matters. We also have a division that deals with international crimes. And also there's a division within the High Court that deals with land matters. So we have so many high courts in our country, Uganda. Now, those placements of high courts in the different parts of Uganda is called the circuits. Circuits. They are not called any other. People call them different names, but we have high court circuits. like the one in Arua, Fort Portal, Gulu, Jinja, Luwero, Masindi, Mbarara, Mpiji, Mukono, Tororo. So we have 20 of them. 20 of them. So in Arua, we have these divisions. In Fort Portal, we have those divisions. However, due to financial and other matters, we don't have all the division in all the circuits. But of course, the headquarters is in Kampala. From the High Court, the next in the hierarchy is the Court of Appeal. The Court of Appeal consists and is headed by the Deputy Chief Justice, and it has other justices of appeal. They should not be less than 7. An appeal shall lie to the Court of Appeal from such decision. So from the High Court, if you are not contented, you can appeal to the Court of Appeal. The Court of Appeal shall be duly constituted at any sitting with an even number, not less than 3. So even number from 3, 5, 7, 9, and so on. So each time it is sitting to preside over a matter, there must be an even number, but also the least is 3. The reason why it is an even number, because if there are 3 judges, you take the majority decision is what we go by. If 2 people say yes, then that is what we go by. So that's why we don't have odd numbers, we have even numbers. Any question as to the interpretation of the Constitution shall be determined by the Court of Appeal sitting as the Constitutional Court. So the Constitutional Court is not a court on itself. It is the Court of Appeal, but it is the same judges of the Court of Appeal that have a special sitting when determining constitutional matters. And after the Court of Appeal, the next court in the hierarchy in Uganda is the Supreme Court. You can find it under Article 130. It shall consist of the Chief Justice and such number of justices of the Supreme Court, not less than 6. So the least number can be 6, but they should be 6 upwards. The Supreme Court shall be duly constituted at any sitting with an even number, not less than 5. There should be not less than 5. Whereas for the Court of Appeal, there can be 3. The least in the Supreme Court, there must be 5. And the Supreme Court shall be the final Court of Appeal. If you are not contented with your decision from the Supreme Court, then it depends also on the matter. We have the East African Court of Justice, but in Uganda, the last court in the hierarchy, the top court is the Supreme Court. An appeal shall lie to the Supreme Court from the Court of Appeal. So matters go to the Supreme Court from the Court of Appeal, then you appeal. However, the Supreme Court has original jurisdiction. For example, in presidential election petition, that one you can go straight to the Supreme Court. You don't need to first go to the Court of Appeal and so on. The Supreme Court, however, while treating its own previous decision as normally binding, may depart from it when it appears to it right to do so. Normally, when the Supreme Court pronounces itself on a certain matter, for example, the bride price, the Supreme Court in that case said paying bride price should not be a precondition for a valid, customary, or any sort of marriage. However, if new evidence emerges, if new position shifts in the law, the Supreme Court can change its position from the earlier decision. So, generally speaking, our court system is in hierarchy starting from local council courts to magistrates court starting from grade 2, grade 1, then the chief magistrates. I implore you to read more from the Magistrates Court Act. Then we go to the Superior Courts of Record, starting from the High Court, the Court of Appeal, and Supreme Court. I also want to add that there are other courts that are established under the Acts. With this, I again want you, please send me the questions about this session to the email here. I appreciate your effort in attending this lecture. Have the best of your time.